Welcome to Brief Encounters and to the June episode of the Securities Regulation and Enforcement series. My name is Valerie Mirko. I'm a partner at Armstrong, Teasdale, and I'm also the leader of the firm's Securities Regulation and Litigation practice. With me is my co-host, William Nelson. William, can you go ahead and introduce yourself?
Yeah, of course, Valerie, and hi, everybody. William Nelson, I'm the Director of Public Policy and Associate General Counsel, the Investment Advisor Association. And Valerie, I'm just, super excited for today because I think, today we're going to talk about kind of one of the hottest of the hot topics. So I think it's going to be a really interesting conversation.
I think so too. And today we're also kicking off a couple of episodes on artificial intelligence and how that impacts our practice, but also the securities industry more generally. And with us, we have Hollie Mason. William, I was hoping you could go ahead and introduce Hollie.
Yeah, of course. And I don't think I'll do it justice, Hollie, but I know that you're a managing director, Secretariat in Chicago, and you specialize in brokerage advisory and disputes. As a managing director, you provide expert testimony and investigative analysis concerning equity and options trading in markets, customary and practices, regulatory and operational compliance, and also risk management, among, I'm sure, many others. You have over 20 years of experience, and also you previously served as Senior Enforcement Counsel at FINRA and a Senior In-house Legal Counsel for a large broker-dealer. So again, Hollie, thank you so much for being with us. It's so incredible to have someone of your caliber on the podcast.
Yeah, absolutely. I'm happy to be here. And I am as excited as you about this topic of AI, and everyone is talking about it. So it'll be an exciting conversation. And hello, everyone. So yeah, I'm ready to get started.
Excellent. And Hollie, when we were chatting about this recording before today, we're really going more deeply into the definitional questions because AI can mean different things in terms of scope. And we're going to talk about some use cases later in this recording. But I was hoping, since you are our first guest to discuss AI, I was hoping you could give us some sort of definitional pillars to work from.
Yeah, absolutely. So, I wear a couple hats. A lot of us in the industry, in the securities industry, wear a couple of hats. I'm a lawyer. As William introduced me, I litigated securities cases for a number of years, but now I'm wearing an expert hat and I do expert testimony. But that means that I use AI differently. It may mean that the definitions that I hold AI, in terms of tools and that are a little different depending on what hat I'm wearing. So today, I think, for purposes of our discussion and our audience, we have three categories of users, which, we have the legal professionals, and thank you to those on the call for introducing this topic in the legal profession. And then two, we have broker dealers and investment advisors, and we have expert witnesses. So it's quite a hot topic for a number of reasons. One, we had a survey put out by Secretariat-international.com. Under our insights page, you can find it, but we partnered with the Association of E-Discovery Specialists, and we sort of surveyed e-discovery specialists and legal professionals sort of doing that work to say, have you used AI to do your work in the past 12 months? And the survey came out to say that about 77% of those parties were using some sort of generative AI technology to sort of facilitate their work. And then in the spirit of AI, if you ask Copilot, are broker dealers and investment advisors using AI? It says it comes out with about 9 in 10 brokerage firms say that they're using AI, and about 70% of that use is for compliance and risk factors. And then, of course, we know just from headlines and case outcomes that experts are using AI for whether it's, helping to draft expert reports or to find relevant footnotes and support for their opinions. So everyone is using AI in these categories of users. And back to your point, Valerie, with definitions, those definitions of AI can be different for those three categories of users. And so I just wanted to throw out that caveat before we start talking about definitions, but I'm going to try to keep it high level for our audience. And so, and those sort of tools that most of these categories of users will run into. And I start by saying that AI, while it's a hot topic now, developed in 1940, believe it or not. And really the purpose of this sort of technology was to come up with a way for computers or computing to mimic human behavior. So that was sort of the purpose. And then that brings us to sort of the umbrella of terms that sort of morphed out of this desire to have machines sort of mimic human behavior. And we start with what we probably all know generally as machine learning. And as you know, in the securities industry, we love our acronyms. We have 100-page book of acronyms in our industry, and this is abbreviated ML most of the time. So in general, I think the three category of users that we're talking about today, legal and brokerage and experts, I think you'll all recognize these terms and maybe have a bit better understanding of what they are when you come across them, or maybe I'm telling you something you already know. But machine learning being, the computer science aspect of using algorithms to assess or process large amounts of data. Now, the difference between machine learning and algos, everybody is hearing algos in the industry. We all sort of got on board with algos when we started talking about like high frequency trading. That was one of the sort of milestones in algos. And, a lot of brokerage firms use algos for various things. But the difference being, I think that's the importance from machine learning between its use of algos and our, traditional thought process behind algos, is that unlike traditional algos, the machine learning is not rule-based, meaning there's rules that you program into the algo saying you can't go outside of these parameters. Whereas machine learning really is using the data to learn and to predict and to identify patterns outside of what it's being told by us, the inputter of information. And we're not giving it necessarily all the parameters for purposes of output. So we'll start with that sort of high level machine learning. There are other types of AI, and I don't want to bore our audience all that much, but there's reinforced, there's deep learning, there's natural language processing, there's computer vision, there's the robotic process automation. And I think, some of these I'll give some, examples of them that may put them more into context, and maybe the ones that we'll come across more in our practice. So the robotics process automation is the last one, RPA. That one I think is the most controversial in terms of whether our group of users would call that AI or not. And I say that because it's focused on, processes akin that look more like that rule-based process that I was talking about, where we're sort of defining the parameters, but it's used in, applications as sort of cost saving. It's a tool that is used in repetitive processes. So things like depositing checks or, doing automated responses. So that's one I think everyone is sort of familiar with and used to seeing. You might have heard it in, or seen it in the context of like a robo-advisor or a chat, automated chat response. So I think given those two bookends in terms of AI definitions, I think we can move forward with our discussion in the context of those definitions and examples.
Thanks, Holly. And that's such a great explanation of the different processes, systems. To follow up on that, you mentioned your survey, which, just to be honest, is terrific. So I really would encourage our audience to take a look. But, one of the things that really jumped out at me when I read through it, and you shared some high level responses was that your survey showed that 80% of respondents rated themselves either very knowledgeable or somewhat knowledgeable about AI. And again, just I guess to me, that kind of stood out, just again, with the complexity of these systems. So I was just gonna, what do you make of that number? I was just curious.
Yeah, absolutely. I think, in terms of the survey of or the user space, I think probably e-discovery specialists are potentially the ones that number is accurate or somewhat accurate in terms of their understanding of the tools that they use for their job. I think we'll talk about later maybe some case outcomes and some risk parameters that show that maybe experts or the other category of our users as broker dealers or investment advisors may not be so savvy in that regard in terms of understanding or being knowledgeable about AI. I think if you're asking AI, do people know about it? Sure. Do they know the difference between, for example, supervised or reinforced based AI or structured or unstructured data or open source or, some of those terms that we've all heard and thrown around? I would say a majority of our category of users may not understand the difference. And I think, from an AI standpoint, I think, the understanding part of it is, most people use, Chat GPT or Copilot or things where they're prompting and they're getting responses and they see where the source data is coming from. From that standpoint, the 80% doesn't surprise me. From the standpoint of things like when you have a risk reward or reward penalty circumstance where you're using an AI tool to teach it and you're rewarding it for being accurate and penalizing it for not being accurate, and you're giving it supervised or structured data versus unsupervised or open source data. I think those are the things where that 80% surprises me and would maybe be a little less.
That's really insightful, Holly. And what I find really interesting about this is, especially in the broker dealer and investment advisor industry, there's been wisely an effort to keep any AI usage a closed loop, which I think is extremely helpful in terms of mitigating risk. The other thing that has been very well done across firms, whether broker dealers or investment advisors, is putting into place policies and procedures and a risk framework to understand how AI is being used as a use case. And furthermore, also how the risk of information leaving sort of, the sandbox is mitigated. So I think a lot was done correctly by the industry in terms of mitigating risk. But I think as a result, there can be this perception by users that within this closed universe, they may know a lot. But once you leave the closed sandbox, that knowledge may not be as high as is currently self-perceived.
Yes, 100% agree. And again, it goes back to those user hats we're wearing, right? As legal professionals, that closed loop is certainly important for broker dealers. I think, the universe of your data or your input is equally important, as well as transparency, understanding, and having a human in the loop. I think both regulators have made that very clear for that broker dealer user space. And then for experts, I think it's, as well, transparency, reliability, I think is one that is repeated over and over, as we will talk about in some of the cases that have sort of shaped the applicable standards for AI use in the expert space. But I think overall, to your point, managing the use of AI for all three categories of users is, transparency, reliability, and understanding the technology that you're using. And a perfect example of that is, any category of user using a third party supported AI technology, right? If you don't build it in-house or you don't control the inputs, what's your level of understanding of that? And in terms of the application, there's also, even to your point, Valerie, if you're building something and the brokerage firm user has, very well controlled the inputs and for their purposes, it's not client facing, but it's behind the scenes, which again is another risk sort of analysis to be done. But you have model drift, you have hallucinations, you have things that can happen within a close set of data as well, which is, something that needs to be addressed by that category of user in that instance as well.
So there are many open questions. I was hoping we could pivot to speak a little bit about use cases.
Yeah.
And because we are a podcast series that's part of the DC Bar podcast, we're also speaking from a practitioner standpoint. You serve as an expert for defense lawyers in enforcement investigations and related matters. Can we talk a little bit about the use case in that setting and some of the risks?
Yeah, absolutely. So we have some use cases in each category of user, but from the expert standpoint, I think we have the most in terms of what has come out in the last couple of years. And I call, use cases, I call those, they set applicable standards, but they also remind us of what those standards are in terms of AI usage as a professional in the industry for experts and for lawyers. We have a couple of cases, here where we have, I wanted to talk about a couple of them. We have more than just the couple I'm going to talk about, but these I think they put the issues in focus here. The most recent one I wanted to talk about was in January. It came out in January of 2025, and it was a district court in Minnesota. And I've labeled it Minnesota ruling on deepfake, and it's sort of just a tagline of how I've labeled the case. But it's talking about an expert, Jeff Hancock, and he was a professor of communication at Stanford, and he was hired by the defense, and he had issued a declaration that the court was commenting on because the plaintiffs challenged his declaration. Because they found fabricated materials and quotes and articles that didn't exist. And after some probing, the defense did admit that they used AI in this creation of their declaration. And they did admit that there was, upon further review, there was fabricated materials and non-existent articles within this declaration. Now, the interesting part isn't that happens, because we all know that happens. That's why we're talking about the cases here, the hallucinations and the errors that, can happen when you're using prompts or using an AI tool to create things. But what's interesting about this is that the defense counsel said, oh, wait a minute, we're talking about this declaration. We would like to have the court's permission to amend it and take out those materials that were deemed to be fabricated on an excusable negligence claim or basis, if you will. And the plaintiffs in response pretty much said, well, look, not only is this declaration tainted, but his entire expert report, any opinions that have been entered in the whole scope of the case are now at issue and tainted because of the reliability issues with him and what has happened with this created or fabricated materials and articles in the declaration. So the moral of the story is that the court agreed with the plaintiffs. There's no, excusable negligence going on here. And not only did the court throw out the declaration, but prohibited the expert from testifying at all in the case and from entering any of the evidence or the reports or the opinions of this expert for the entire case. So again, moral of the story, you want to do a quick declaration, you've got your motion practice going back and forth. You've got, quick deadlines and quick turnaround times for these rebuttal reports and declarations that may be necessary when you're doing a litigation matter. And yes, while AI is a helpful tool in terms of, expediency or efficiency, you not only risk, whatever you're crafting or drafting or testifying about being thrown out, but you risk reputation, you risk the entire case. And, as litigators, we know that an expert report is in most instances, one of the most expensive parts of litigation in terms of the expert. And so you're doing a disservice to your client if the entire, year or two workup of an expert report is thrown out. So it's just a cautionary tale, I suppose, that it doesn't matter if you have one footnote in a declaration that comes later down the line, you could put your entire case at risk in terms of the use of this expert.
Because it really comes down to the expert's credibility.
Absolutely. And I mean, this judge in this case was talking about a reliability standard, and he didn't actually apply the standard that we all know as 702, the Delbert standard, in terms of, the admissibility of expert testimony. He sort of used something similar and relying on, this, what he called a reliability standard, and using 702 as sort of a guide. But most cases, like the next one that we're going to talk about here in New York, that's what they're using. They're using 702 to say, listen, is this a reliable method? Is your opinion based on a reliable method? And is it, based on sufficient facts or data in terms of margin of error or, accuracy? And I think, the standards under 702 is something that experts are going to have to be mindful of when they make decisions about using AI and on a case-by-case basis. This case in New York it started as a real estate dispute, and it was in October of 2024. And Susan Weber was a trustee of her nephew's trust, and this was just essentially a dispute about whether the use of a house, I believe she was living in it or something, or allowing folks to live in it, and whether that was a proper use of trust property. And so there was some damages calculations done to say, look, this damaged the trust, her use of the house, and not, putting it out there for, rent or marketability or those things caused damages. And so the expert was a damages expert, essentially, for those representing the nephew's interests, and the expert couldn't specify the prompts or the inputs that he used. And this is one that we use all the time, Chat GPT, and I'm sure a lot of our listeners have used that, just whether it's just to see where to go to dinner or, or to see where to go when you're in a foreign country or whatever. But this expert had used it to assist in certain calculations for purposes of damages, and he couldn't tell the judge what those prompts were, the input that he used. And I think he also used the Copilot tool. And what was interesting, and what I find interesting about this case, and the reason that I wanted to talk about it, is that the judge himself, or somebody in his space, actually tried to get the result that the expert was purporting to have gotten from Copilot by putting in their own prompts and putting in their own inputs, and they couldn't repeat it, meaning that they couldn't back into the result. And as litigators, and I know as an expert, that you provide your work product to the other side so they can actually essentially rebuild your analysis, and they couldn't do that. And they tried to do that just for purposes of trying to give the expert the benefit of the doubt, I suppose. But the court tested it, and in doing so, the results said that they should be checked or tested by humans. That was the result of the search for Copilot's response to the search that the court was doing, trying to recreate this expert's damages analysis using Copilot. And so it's an interesting take on it because I can see that being an issue for experts, and that, we may be transparent. We may know the tools that we're using. We may know the prompts and the inputs, and we provide that to the other side so they can, sort of recreate our analysis, but it could come up different. And that's the risk of AI and learning, and, things that are within the scope of those tools. It's constantly, shifting. And so they may not be able to recreate it, even though we've given them the transparency necessary. It may come up different when they put in those same prompts. So it's an interesting case. On the opposite side, you could have, opponents or other side saying, why didn't you use AI? It's an efficient method. It's proven in this space to be more reliable than doing calculations via Stata or SAS or some other method. So we may end up getting there too, to say your decision not to use AI might be under a microscope as well. So it's just an interesting bit of information and cases and how they came out. Obviously, the experts' analysis, the damages analysis, was ruled not to be credible and thrown out. But I think these two cases sort of show what we're in for in terms of expert testimony and cautionary tales of using it and making sure that we're following the rules of the road when we do.
Yeah, and that's fascinating. I guess one thing I'm a little bit comforted by is that humans are still in the loop, at least as of now. But I did want to follow up. You did talk about some of the risks. Looking at hallucinations. Data governance. One of the other notes I made in the survey you provided was that when asked where they think Gen AI, generative AI, will have the biggest impact on the legal industry, cybersecurity and privacy were actually at the bottom of the list. And at least to me, as a former chief compliance officer, that was a little bit surprising. So I didn't know what you made of that.
Yeah, absolutely. So I think it's interesting to me because if you're looking at it from, for example, the Securities and Exchange Commission side, that I think their focus is really on the disclosure and the conflicts and things. FINRA's focus is more on the supervision and the oversight and, the built-in processes and transparency. Of course, generalizing their position on this for the brokerage industry. But I think I say that all to say that records and what is a record is becoming an issue, which then goes to the cybersecurity and privacy side of things. And I think, the opinion currently is AI a business record is still a question that is unanswered and on a case-by-case basis. So I think that's the reason why you're seeing those percentages so low, is because really cyber and privacy comes into whether it's PII or whether it's information that we consider a business record. So I'm sitting at my computer at a brokerage firm and I'm using, let's just say our policy is that Copilot could be used for, non-client facing functions. So I'm sitting there and I'm using it and I'm chatting with it about, what's the next big stock, or I ask it something, just general like that. Is the output of that considered a business record because I'm sitting in my seat at my job, or is that just since it's outside the scope of my job and my function as, let's just say, a compliance officer, then it's not a business record. And so I'm not documenting that for purposes of record keeping and how firms keep track of, what they're going to consider in terms of AI processes. What the output is the learning process, or is the prompts, or in what circumstances are these things records? And that's going to feed into that cybersecurity and privacy, because until they start doing, things that AI for AI purposes, really for compliance and risk, the firm just needs to document those things for supervisory purposes and for oversight to say I'm in compliance with the rule. But when you're talking about, things when it switches to client facing and you've got your disclosures and you're using, your inputs are client data and client information, that's when I think you're going to see that percentage increase a little bit more in terms of what industry users of AI are going to expect. That'll become a higher issue once we're talking a little more about client-facing AI.
Yeah, and that is really interesting, Holly. And I guess on that point, you did raise the issue of rulemaking. We've seen the SEC. They came out with their predictive data analytics proposal, obviously a little bit broader than AI, covered a lot of different technology, growing state level legislation. 48 states now have introduced bills, 26 have adopted some form of AI related legislation. So, in your perspective, what are some steps firms may want to take now if they're kind of looking to integrate AI into their practice?
Yeah, and you're right. Even the Minnesota case that we talked about, where the expert report was thrown out because of the fabricated materials were in the declaration, that case was Minnesota's sort of anti-deep fake law, right? So it was very state specific, and it was in the political realm, not in the broker-dealer realm, but it was still, it still had to do with that. And, we're seeing rules, like I said, the AI rules, we had the SEC in 2023 sort of attempt to address AI via conflicts of interest. And we had a lot of industry pushback on that based on the fact that a lot of folks in the industry said that rule was sort of already covered by Reg BI to a certain respect, in a certain respect. And then we have FINRA saying, well, all the current rules sort of cover those activities, whether it's communication with the public or cyber or the other rules that have to do with supervision, 3110 and those. So we've got a couple of different camps in terms of rules of the road. And I think generally, firms, whether you're an expert, whether you're a broker dealer, or whether you're a legal professional, I think, it's a case by case assessment at this point. You want measurable output reliability. You want, a common understanding of the tools you're using. You want a plan and, you want a planned approach. And again, I think that's addressing model drift and hallucinations in any sort of AI technology you're using. And I think training is very key in terms of, especially in the broker-dealer space, that you want folks using the tools that they understand. And I don't think it's going to be much different than any other technology, where if FINRA or the SEC come in to do an examination and they're asking your associate the reason why they're using this technology, or what it's for, or the purpose, or how you came about using it, I think they need to be able to answer that question. And, the formulas, the data inputs, the human in the loop thing is always going to be, for any category of user, is going to be key. And then transparency is the other one. Like, I know at our firm, we have an AI policy, and we disclose who has access to it, when they can use it, what permissions they need to use it. We have discussions with our clients about, should we use it? So I think, documenting and being transparent about when you do and what's the scope of that, as well as disclosure, and having those discussions with your clients and having those risk-based conversations in-house are key. And, just the clarity on the output, we all just need to know, what the output is and what it's based on. And I think that's going to be true for any category of user.
I think that's exactly right. And I did want to take a couple minutes for us to discuss AI washing settlements, particularly in terms of SEC settlements in the last 12 to 18 months. And those have really focused on the transparency and disclosure aspect,
right,
about the use of AI. So, so far we've talked a lot about how to responsibly use AI, whether as a practitioner, an expert, or as an industry participant, but sort of shifting to the disclosure element. which is where both, investment advisors and public companies and private companies have all run into issues, is the AI washing element. So, Holly, we talk a little bit about that in recent settlements.
Yeah, absolutely. So AI washing, the SEC has sort of coined that term, and it essentially boils down to the fact that you're not doing what you say you're doing, or the opposite. Meaning, I think I'm not sure when the term first was used, but Gensler's talking about it in his speech in March in 2024, talking about reasonable basis and claims of use when you're not using AI. And then, the claiming that you are using it, and disclosing the opposite, I think is sort of the best way to approach that. And he just said that, what our expectations are, you should say what you're using and what you are doing, and do what you say you're doing. And so that's when folks have run into this AI washing situation, where the SEC has sort of cracked down, saying, look, your disclosures are inaccurately portraying what you're using AI for, or that you're using it at all. So in the most recent press release, I think was in 2024, where there's a couple of investment advisors that reached settlements with the SEC. Delphina and Global Predictions, I think, were the two, if I recall. But essentially, the SEC concluded they were making false claims to their clients, that these two investment advisors were claiming that they used AI for investment opportunities or investment performance or analysis, and they were in fact not. And so that's where the SEC is more on the disclosure side, and just like Gensler said in his speech, do what you say you were doing, and and make sure that you understand what you're using AI for, the disclosing it properly. And so that's sort of this AI washing. There's also companies, that term has been used to describe companies that make disclosures on, for example, their business 10Ks or other public disclosures, saying about, we're using AI for this purpose, or we have no AI risk, or we do have AI risk. And so the SEC has on occasion found that some of those statements to the public about those items have been inaccurate for purposes of shareholder or investor disclosures. So that term has been used in a couple instances.
And Holly, I think what you're teeing up really well is that while the AI washing concept was coined during the time when Chair Gensler was SEC chair, the concern has continued through the transition to Chair Atkins.
Yes, absolutely. I don't think it's going away, and I don't think it's going to change in terms of their focus. I mean, transparency as well as accuracy and in disclosures can be tied to, investor harm if it's inaccurate or not reliable, or the statements aren't on a reasonable basis, I guess, if you're looking for the standard that they use. But yeah, I agree with you, Valerie. I don't think it's going away. The FINRA approach, again, is a little different, where FINRA hasn't focused on, enforcement or AWCs or disciplinary actions so much in the AI space. I think last year there might have been one where it's more supervisory focused, and they found a firm, their policies and procedures didn't accurately describe how they were using the AI or what the end result was as a result of its use, and it wasn't being properly supervised by humans. And the firm was actually using the AI for purposes of AML. And so you're seeing a little less involvement by FINRA in terms of their mention of AI or things tied from a disciplinary standpoint or enforcement standpoint to AI, where FINRA is, again, human involvement, supervisory processes, documentation. The SEC is conflicts of interest, disclosure, accuracy of describing processes and claims of use. So a little bit different approach, but I think we're going to see both moving forward a lot more.
Thank you, Holly. This was super helpful. And also, it's not just the SEC and FINRA. So, for example, one of the latest SEC settlements in April of this year also was a parallel case involving the DOJ as well.
Yep.
I think we'll see other regulators and government agencies interested in this. We're seeing it at the federal level. We're seeing it at the state AG level to some extent.
Yep.
And I don't think it's going away, like you said.
No, I agree with you 100%. And it's just going to expand when use upticks and people start, putting dollars behind, building tools or purchasing tools, or, others in the industry are forcing firms to get on board, right? That's happened before too. Whereas, you've got bigger firms or you've got a lot of firms using it, you've got smaller firms that sort of have to jump on board to be competitive. And I think we're going to see that uptick here soon. And you're right, you're absolutely right. Even with, we've been talking about sort of the SEC and FINRA and the broker dealer investment advisor space, but you have just, recently you have, I think it was in May, a lawyer in Utah, an appellate court issued sanctions for, I think it was an interlocutory appeal, and his appellate brief included false citations, and he was sanctioned by the court. So we're seeing that side of things too, in addition to, the expert side where courts are throwing out their opinions or reports under 702. We also have global, right? Those of us who practice globally, you've got the EU who has put out a very detailed AI law. And so firms need to be mindful if they do business there, or even as legal professionals, if we partner with folks in our global offices, they've taken a risk-based approach and a category approach. So and they've prohibited certain uses of AI, such as using my likeness and things like that. But they've put AI tools into categories, and they've rated them for all intents and purposes based on risk. And then, you have to abide accordingly, depending on what category you fall into in terms of that AI tool. But it's very specific. It does bar some uses and some AI tools. And so firms that are global should certainly take a look and address that in whether it's their policy or their processes, to make note that either they're excluded from it for this reason, or they've considered it, or they don't fall within the risk-based categories for whatever reason.
So, Holly, we've covered a tremendous amount of facets of AI in the last 30 to 40 minutes. Is there anything else we should have asked you about?
No, I don't think so. I think, as always with podcasts or, talking about, a topic, I like to give some takeaways just at a high level. AI tools require caution, I think still. I talked about at the beginning that, we've had them around since the 1940s, but we're just seeing new uses for them. We're just seeing various, industries that we all dabble in, implement them in new ways. And I think, they still require caution, whether you're an expert doing statistical analysis, whether you're a legal professional trying to, offer some, efficiencies, or to even use them to check, expert work, or check an associate's work, or look at an opposing report or draft a contract. I think we're still talking, some pretty high level human involvement and oversight here necessary. We're obviously developing close-end tools on our end because we recognize that, it's one of those from a privacy standpoint, as well as being able to control inputs and decide how the output looks from a learning or drifting or hallucination standpoint. I think close-in tools at least in the legal and expert space, are going to be around for a while. But I guess takeaways, AI tools still require a case by case and cautionary approach. And then on the other side, always demand transparency. And I think it's prudent for experts and legal professionals to not assume somebody hasn't used AI if they don't disclose it, or to see if that's a valid concern from opposing parties, or to talk with your clients about any use that you plan on using it for, whether it's drafting or research, just so everyone's on the same page. Obviously a case-by-case approach, not all practice areas AI is infiltrating at this point, but it's a good discussion to have if you're using it, and, let them know what your policy is. And just remember that AI, obviously everyone knows that it comes with its own set of due diligence. So the efficiencies that you may be getting, at least initially, when we're all still feeling our way around, they may be not as efficient as you think they are in terms of the back end due diligence that's required until we all get up to speed on, the tools and the process and, the testing, verification, understanding. Those things do take time. So if you are working with an expert firm or you're working with a lawyer, those that dabble in the space, make sure that they have a full understanding of the tools they're using, and that they're testing and doing some verification on those.
And that's some really great and useful takeaways. Thank you so much, Hollie, for joining us today. William, do you have any last questions?
No questions. Just again, a big thank you to Hollie. It's what I love about these podcasts is I always come out a little bit smarter, and it's really thanks to our guests like Hollie. So again, thank you, Hollie. This has been wonderful.
Yeah, absolutely. It's been my pleasure, and I look forward to publication.
Thank you, Hollie. Thank you, William. And thank you to our listeners. Until next time.